All right, so this is the first lecture for our first module. The first part of Chapter 1 gives us some background to voting rights, and I highly recommend that you look at that closely, especially if you're rusty on your constitutional law or haven't yet taken constitutional law. There's some good background material there that will be useful, especially with regards to the Equal Protection Clause and the Due Process Clause. Before we get into the cases, I just want to go through a brief overview of the relevant constitutional texts that concern election law. Now, we're not going to be going through all of these provisions during our course, but it is important, I think, that you know where voting rights are discussed or mentioned or implied throughout the Constitution. So the book starts out by mentioning the Guarantee Clause of Article 4. And I would recommend that you have a copy of the Constitution in front of you for this lecture and most of these lectures in Chapter 1. So if you don't have a copy of the Constitution, I suggest just pausing for a moment and going to find one. So the Guarantee Clause, Article 4, Section 4, states the United States shall guarantee to every state in this union a republican form of government. Why is that relevant to voting? Well, a republican form of government is usually contrasted with, on the one end, a monarchical government, which is governed by one king and everyone is subordinate to that one individual's will, and a pure democracy, where the people themselves vote on every measure or law. A republican form of government is somewhere in the middle. The people don't vote on every law, but they do vote for the people who make the laws. It's a representative form of government. So perhaps the Constitution does guarantee then that the people be able to vote for their representatives, right, indicating the importance of the vote. Then we have several clauses that do mention how and when members of Congress get selected. Again, perhaps emphasizing the importance of it, the Republican form of representative government. Just for example, let's just look at Article 1, Section 2, Clause 1, which talks about the House of Representatives. That section says, the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So this section of the Constitution indicates that in order for a member of Congress to be validly selected, he must have been chosen by the people of the several states. So there is then at least some indication that the people must be allowed the chance to vote if any members of Congress are going to be legitimately elected. And that clause will become more important when we get to the one person, one vote chapter. Then we have the amendments to the Constitution that essentially expand the franchise, and that's one of the historical points that you'll want to appreciate, is that the story of election law is largely the story of an expanding electorate. So the 15th Amendment in 1870, which is the last of the Reconstruction amendments adopted after the Civil War, the 15th Amendment prohibits racial discrimination in voting. And we're going to be looking at that today in this lecture. The 19th Amendment prohibits discrimination based on sex. The 23rd Amendment guarantees the District of Columbia electors for president and vice president. The 24th Amendment prohibits poll taxes, which we'll look at in the next lecture. And the 26th Amendment guarantees the right to vote for 18-year-olds. So let's look at the 15th Amendment. The 15th Amendment says the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Congress shall have the power to enforce the article by appropriate legislation. So Section 1 prohibits discrimination outright. And then Section 2 allows Congress, it gives Congress the power to pass laws in an effort to enforce the prohibitions contained in Section 1. So with that in mind, let's look at the first case that we have, Lassiter case, which is about literacy tests. So why might a state have passed a law requiring a literacy test in order to vote? And what are some arguments against these literacy tests? And these are given in the notes right before and after the Lassiter case. So in favor of literacy tests, a state might argue that this is a way to demonstrate intelligence or knowledge. We want an intelligent and knowledgeable electorate, so why not have some way to actually test that intelligence or knowledge? Maybe a state thinks that a knowledge of English is important, and a test would guarantee that sort of knowledge. Or maybe a state is interested in making sure that immigrants are assimilated into the American political culture. And a literacy test might do just that. You can think of, we require tests for citizenship. Maybe this is a way of trying to get at that same idea. On the flip side, we could imagine that a literacy test might be administered in a discriminatory way, and relatedly, you might think that there might be too much executive discretion. In other words, if a test allows for not necessarily a clear or a right answer, you might imagine a grader of one of these tests being more lenient on, let's say, a white person than a black person. And in that sense, the administration might be discriminatory. There also might be there also might be a discriminatory motivation or impact. So even if it was, let's say, a multiple choice test in which the grader couldn't discriminate based on race, maybe the underlying motive was to discriminate based on race. Maybe a test was designed knowing that it would have an impact on black people more than it would have an impact on white people. And that might be problematic as well. Well, let's look at what the court says about a challenge to literacy tests. So this case comes from North Carolina, and we can see the statute that's being challenged in footnote 1 of the Lassiter case. The statute says, every person presenting himself for registration shall be able to read and write any section of the Constitution of North Carolina in the English language. So what's wrong? What's the claim that that is an improper or an unconstitutional statute? The court starts out by noting that the right of suffrage is established and guaranteed by the Constitution. So the court says that at the top of page 9. But it's subject to state regulations that are, one, non-discriminatory, and two, not preempted by federal law. So that's simply a way of saying that although there's this right that's established and guaranteed by the Constitution, the states are free to regulate the electoral qualifications so long as they do so in a non-discriminatory way, in a way that Congress has not said they can't. Right? So is this, and there's no, at this point in time, in the next case, we're going to see Congress does act, but in 1959, Congress had not acted yet, so that second point is not relevant. But why is a literacy test not discriminatory in the constitutional sense? Is literacy a suspect classification, we might ask, to use the constitutional, the term of art in constitutional law? Is literacy a suspect classification? Well, the court says in the middle paragraph on page 9, literacy and illiteracy are neutral on race, creed, color, and sex, as reports around the world show. So those seem to be the suspect classifications: race, creed, color, sex. Those are the classifications that the court is worried that a state could discriminate based on. But literacy itself is not a proxy for one of those classes. And in fact, the court says there are legitimate reasons for making literacy-based distinctions. Right? As the court says in that same paragraph, in our society where newspapers, periodicals, books, and other printed matter canvass and debate campaign issues, a state might conclude that only those who are literate should exercise the franchise. So the court is not worried that a literacy test in and of itself is a proxy for a suspect class, because there are legitimate reasons that a state might make literacy-based distinctions. A state might say, we want a well-informed electorate. How does an electorate get well-informed? By reading the newspaper, by reading up on the candidates. And a way to make sure that the electorate is well-informed is to give them a literacy test. Right? And secondly, we're not concerned that illiterate is the equivalent of black. Right? That's essentially what the court is saying here. We're not concerned that illiterate is inherently the same as black or African American. So the court holds that literacy is not a suspect class, that there is no problem here. The statute is only subject to rational basis. The court can easily understand why a state might adopt a literacy test, even though the court itself might not agree with it. This is a very deferential review of the state statute here. All right. So literacy was not the equivalent of race discrimination. What about Section 2, however? As I just mentioned in Lassiter, there was no federal law yet. But in 1965, Congress does pass the Voting Rights Act. And the Voting Rights Act is partly based on Congress's Section 2 powers under the 15th Amendment. So in making sure that the states don't discriminate based on race, Congress enacted a law that prohibited literacy tests in some areas. And that is what the next case, South Carolina versus Katzenbach, is about. So the Voting Rights Act, part of it was concerned with states that had a history of racial discrimination in voting. In the case itself, the court goes through some of the problems that Congress faced in trying to enforce non-discrimination in voting throughout the South. The South had they came up with any number of ways to discriminate against African Americans, and the Voting Rights Act was Congress's most comprehensive attempt at combating that racial discrimination. Now, the act did not apply uniformly throughout the United States. There was something called a coverage formula, which is discussed on page 15. And it's only states that were covered by this formula that were subject to some of the restrictions of the Voting Rights Act. So if the Voting Rights Act applied to a particular state, what are the remedies that a state would have faced? And we can see this under Section 2, the first paragraph on page 15. If a state fell under the coverage formula, then that state had to suspend any literacy test for 5 years. The state had to suspend all new voting regulations pending a review by federal authorities. And third, the state might have federal examiners assigned to essentially watch their actions. So how did a state get covered? How did a state become subject to those three things? Well, that's discussed under the coverage formula. So one of the ways that a state became subject to having that sort of federal oversight is if, this is the coverage formula, 1, it maintained a test or a device on November 1, 1964, and 2, less than 50% of the voting age residents were registered or actually voted in the presidential election of 1964. So put together, the idea is that those two factors, the use of a literacy test and the low voter registration and turnout, were good indicators to Congress that the state was engaged in racial discrimination. And if a state was one of these covered jurisdictions, then it was prohibited from using literacy tests for 5 years. Right? And the court says Congress was perfectly free to make that sort of determination. It was well known that literacy tests were used to discriminate, even though the court in Lassiter had said that literacy tests aren't inherently discriminatory. Nevertheless, the practical use of the tests had been to discriminate. So Congress was well within its rights to combine those two factors, the existence of a test and the existence of less than 50% voter participation. Right? So in other words, Congress could put two and two together and say, there's some problem here in this state. Right? And as we'll discuss more in more detail in the next case, the next Katzenbach case, the Morgan case, what the court says is that Congress's power, the remedial power under Section 2, is greater than the power under Section 1. So even though a literacy test might not in and of itself be evidence of racial discrimination, Congress is at liberty to prohibit the tests in order to remedy current and future racial discrimination. Right? And so that sort of coverage formula the court upholds. Right? So think about that Section 2 power and compare it to the Section 5 power that the court upholds another part of the Voting Rights Act under the 14th Amendment's enforcement power. So Section 5 of the 14th Amendment is the equivalent of Section 2 of the 15th Amendment. And the power of Congress under both of those sections is equivalent. But the important thing to appreciate is that the power of Congress is greater than the substantive provision of Section 1 of those amendments. Right? So just because, another way of putting this is, just because an action of a state is not prohibited under Section 1, the substantive provision of the constitutional amendment, doesn't mean that Congress can't prevent the state from doing that. All right? And hopefully that will be clearer in the next case.